And welcome to the Goldwater Institute's recap call to discuss today's oral argument in the Proposition 208 case, which is a lawsuit challenging the constitutionality of the recently enacted tax increase here in Arizona, which creates a heavy imposition on Arizona's population in order to fund additional spending on public schools. The constitutionality of this initiative was argued in a hearing this morning that was presented on our side by Dominic Dre, former Solicitor General of Arizona, who's on our team, and he's joining the Goldwater Institute in litigating this case, along with his colleague, Brett Thompson. And I'm going to be talking about the case and the hearing, what we saw today, with my colleague, John Riches. We'll cover a little bit about what happened today, what we can expect in the future, and you can ask your questions by pressing *9 in order to be placed in the queue to ask your questions in a few minutes. I'll remind you of that shortly. First, though, I want to turn the mic over to John Riches to talk a little bit about what this case is about, what the legal issues are, and what you thought about the argument today, John.
Hey, thanks, Tim. What a great morning. But let's step back and talk about how we got here, what was before the court, and then what occurred this morning. So as many of the callers are probably aware, Proposition 208 imposed the single largest income tax increase in the history of Arizona. Prior to its adoption in November, the top income tax rate was 4.5% in the state. Prop 208 added an additional 3.5%. So it took the top rate up by about 80%. Now, prior to the adoption of Prop 208, Arizona was one of the better taxing states in the country. As a result of 208 and its implementation, however, Arizona is now the 10th highest taxed state in the country. So, that took us from pretty good company with some of our neighbors, Texas, even Colorado, and some others, and put us in the company of states like New York, California, and New Jersey. And look, why is this a problem? You can't raise the top tax rate by 80% without serious economic consequences. Lost jobs, lost revenue, lower wage growth, lost migration. I can't tell you already how much we have heard from small businesses, from individuals who said, look, after this thing's adopted, I'm going to relocate outside of Arizona. I'm not going to come to Arizona. And look,
and this tax, John, this tax really falls heavily. You mentioned small businesses, particularly heavy on small business owners, and in a time of an virtually unprecedented economic recession.
Yeah, that's exactly right. Look, this thing was sold as a measure that, quote unquote, was only going to raise taxes on the rich. But as you said, Tim, look, this thing falls on a lot of middle class wage earners and small business owners. Half of the people subjected to the tax are small business owners that file through pass-through entities. So some economists that have looked at this has estimated that this is going to have punishing consequences for just those small businesses that, like you mentioned, Tim, were just smacked in the gut by COVID and by economic recession. They're trying to get back up. They're punched right again with the implications of Prop 208. So, I mean, look, as a policy matter, this thing is just devastating for Arizona. But I think kind of more important for purposes of this call, and frankly, for purposes of how our constitutional government ought to operate in this state, there were serious legal defects with the proposition as well. So, Tim, I know you're going to talk more about this, but broadly speaking, the two issues that were before the Supreme Court, and this was on a preliminary hearing, but the court certainly took these up at least took one of these up on the merits. The two issues that were before the court was essentially how money can be spent in the state and how taxes can be raised in the state. And the state constitution, Arizona's constitution, places limits on both of those things. So I think it's important for the callers to know, first, Proposition 208 was passed as a simple statute. When measures go to the voters, they can go to the voters in one of two ways, either as a statute or as a constitutional amendment. Prop 208 went as a statute. Now, why is that significant? Because the Constitution places limits on how money can be spent for statutory measures in the state for public education. And what Prop 208 did was try to expressly exempt itself out from those constitutional limitations. There's literally a portion of the law in Prop 208 that says, we know that there's these expenditure limitations that apply in the Arizona Constitution to public education expenditures. Well, for purposes of this initiative, they don't apply. So I think we all learned in kind of basic civics class, a statute can never, simple legislation, whether it's passed by the voters, whether it's passed by the legislature, can never exempt itself from the Constitution. So that was the first issue before the court, and really it was the one that occupied most of the court's time. The second issue was limitations that the Arizona Constitution places and how taxes can be raised in this state. There's a provision of our state constitution that says any act that provides for an increase of revenue in the state, any act, has to be passed by a supermajority of the legislature. Of course, Proposition 208 was not passed at all by the legislature, and it was passed by a razor-thin majority of voters. So that's the overview in terms of kind of where we are at. Tim, you were in the courtroom this morning. Why don't you talk about your impressions on how the hearing went?
Yeah, and you emphasized this thing about the will of the voters. That came up a bit in today's hearing. Which, by the way, if in case anybody's listening who didn't watch the hearing, you can watch the video of today's argument on the Arizona Supreme Court's website if you just look up their oral arguments page. This thing about the will of the voters came up because, of course, you're talking about the legality of a ballot initiative. And whenever there's a case that challenges the legality of a ballot initiative, people say, well, you're trying to disrupt the will of the voters. What about the will of the voters? And as Dominic Dre said when arguing our side of the case this morning, every part of this case is about the will of the voters. The constitutional limitations on spending and on tax increases, which this initiative violates, both of those were added to the Arizona Constitution by the voters in ballot initiatives in previous years, in 1980, 1992. And those provisions say you can't raise a tax without getting a 2/3 vote of both houses of the state legislature, and you can't spend beyond the limitations that are set forth in the Constitution. So if we're talking about the will of the voters, it's the will of the voters who amended the Constitution that really should be enforced. And I think Dominic really got that point out really effectively in his argument today. Now, today's argument did not go into a lot of constitutional discussion. As you mentioned, John, the justices really didn't ask questions about the supermajority vote requirement, for example, for tax increases. And that's because some of today's hearing was really devoted to the sort of preliminary things about a lawsuit, right? Whether you're allowed to sue, whether you have to sue later, those kinds of technical things that really only a lawyer can love. And this case, like you mentioned, is on a preliminary status at present anyway, because what happened was we filed the case in December and asked the judge for a preliminary injunction that would postpone the implementation of this tax until the court could decide whether or not it's constitutional, because it would waste everybody's time to have this tax go into place, then later declare it unconstitutional, and then have to go back and undo it and like refund people's taxes. And so that'd be a real pain in the neck. So instead, what we said was, why don't you just postpone implementation until the judges can decide on the constitutionality? The trial judge said no to that, so we appealed and then we asked the justices of the Supreme Court to use an emergency procedure to take the case immediately, and that's what they did. So today's hearing was technically just about this aspect, this preliminary motion to postpone implementation before the case is decided. And at the end of the argument today, we asked the justices to decide it as quickly as possible, even just issue what they do sometimes, a one-page decision, and then follow it up with a more thorough explanation later. Sometimes in urgent cases, that's what the court will do. It'll issue a one-page order, say, okay, we're ruling in favor of the plaintiffs or whatever it might be, and we'll explain later. And then months later, they issue a full opinion. So we did ask them to do that. As far as how today's hearing went, John, you were watching online. I was there in the courtroom. My impression was that the justices, well, first of all, I thought the justices were very familiar with every aspect of this case. The questions sometimes got pretty technical about the finances involved in things. And I think both the justices and the lawyers on both sides were really capable in answering those kinds of questions. And I got the feeling that the justices were mostly concerned about two aspects of the case. And that is, the first one is the initiative backers claim that this initiative creates a grant system. And the reason they say that is because the constitutional spending limitations have an exception in there for grants. Those aren't subject to the spending limits. So the other side, the backers of this tax increase keep trying to say that this is a grant. Well, that's kind of silly, honestly, because it's a tax increase followed by mandatory spending. That's not what you mean by grant. When you use the word grant, normally what you have in mind is something like a scholarship or something where you get it based on merit or something like that, where you're not entitled to it. And here the program is about a mandatory entitlement spending. So that strikes me as a pretty hard argument for their side to make. And I got the feeling that the justices weren't particularly into it either. And then the second issue was this question about whether the legislature can override these spending limits. And the reason they asked a lot of questions about this is because there is a provision in the Constitution that allows the legislature to override the spending limits 1 year at a time. And so then the question was, well, then do we have to decide this case now, or can we decide it later? And courts really don't like to decide cases if they don't have to. So a lot of the argument today was over that. And this is, lawyers call this ripeness. And I think our side made a very clear argument that the possibility that elected legislators might raise this spending limitation one time, that does not show that this case is too early. All that shows is that there's a small escape hatch maybe further on down the road, and that's not a good reason for the court not to decide the case today. So that occupied a lot of the court's time, especially toward the end. And I think if people out there have watched that argument, you might be kind of puzzled by that. That's why they're asking all those kinds of questions. They want to know whether this spending is really going to exceed the constitutional cap, which it is, and if there's any way the legislature can prevent that from happening. And there's, kind of sort of a temporary stopgap, but it's not enough to make this case, too early to decide.
Yeah, Tim, I think all of us were, what we did not want to see happen was the court get bogged down in procedural/technical issues where the court would not reach the merits, or maybe the court would try to avoid the merits of the case. But I'll tell you, I was very encouraged. Really, I was very encouraged by the questions today. But prior to getting into the hearing, just the fact that the Supreme Court took it, I think it was a positive sign. A lot of our callers probably know that the Supreme Court is a court of discretionary review, meaning they don't have to take cases. They can let them play out in the lower courts. But as you mentioned earlier, the Supreme Court elected to take this at our request. That's a positive sign. And boy, I think the questions today, they were focused really on merits type questions. Like, look, yeah, I think a lot of the implications was that, look, even if we agree with you, or if let's say we agree with you that the statute can't exempt itself from the Constitution, well, then what should we do? Is this severable, as lawyers like to say? Tim, why don't you give a little background as to what severability is and why it's important here, and what do you think? How the court can come down on that issue.
Yeah, that is a major concern. So severability, of course, is the idea that if the voters pass like a really big law that has only one tiny part that's unconstitutional, well, then it doesn't not make sense to invalidate the entire thing over one tiny part. On the other hand, if you have if the voters approve something that's huge and has all sorts of constitutional problems with it, and only one or two parts of it are any good, then it also doesn't make any sense to leave in place the few good parts if the rest of it wouldn't work. So lawyers call this severability. The question of how much of a partially unconstitutional law should remain on the books when you strike down the unconstitutional part. And the rule is typically, well, we ask whether the voters would have wanted the rest of it to stay in place when we take out the bad part. And in the case, and you certainly, if you've listened to the oral arguments, you heard a lot of questions about this. In this case, Of course it's not severable. I mean, the entire point of this ballot initiative was to raise taxes and then turn that money around and hand it off to the public schools. And the idea of severing it, if you were to try to do that, what you would leave in place, since the spending parts of the law are unconstitutional, what you would leave in place is a tax. So then what you would be basically doing is stockpiling tax money that can't be spent, right? And that doesn't make any sense. Voters would not approve of that. And I think, as Dominic Dre said during the oral argument today, no rational voter would have approved of this. He in fact, there was a good metaphor he used. He said it'd be like buying a car when the dealer tells you, well, it can't drive further than 100 miles. But you have to keep filling up with gas every day, right? It's like you have to keep putting your tax money into this thing, but it can't drive you anywhere. And that doesn't make any sense. And so when the judges decide a severability issue, they're trying to predict what voters would have wanted to do if they had known that the court was going to take out part of it as unconstitutional. So the question is, would the voters have wanted the tax to remain in place if they had known that the spending part was going to be taken out? And the answer to that is no. I mean, the entire initiative, the whole idea behind it, the campaign in favor of it was to say, well, we're not spending enough money on public schools, which, by the way, is not true, but they're insisting that we need to spend more money on public schools. So if you take out the spending part, then what you have left is really part that doesn't make much sense. So that's why so much of the argument was devoted to that. And I think when we talk about today's hearing, we talk about the possible outcomes. I think there's basically three possible outcomes here. One is our side could lose entirely. The judges could say, no, this is entirely constitutional, period. In which case, the case would be effectively over at that point. I mean, there's still part of this case that for procedural reasons is still in front of the trial judge. So that part could still proceed. That's one possible outcome. Another possible outcome would be that the court could say, no, this is just totally unconstitutional. And we did ask the justices to do that because there's really no reason to have any trial or any development of evidence or anything on that question, right? This is just about a legal issue. So there's no reason to have a trial, which is all about finding facts. So that's another possible outcome. And then the third possible outcome is that the justices could say, we're going to issue the injunction, and then we're going to ask the trial judge to proceed with the case and find more facts and then decide it. And then we'll take it on a second go around to address the rest of the questions. And that's a possibility. Personally, I sort of suspect that's not going to happen. My own impression, just kind of reading faces there in the courtroom, is I think the justices are going to want to say, are going to want to answer at least one of these questions all the way through. And if they answer one of those questions and say it's unconstitutional, then they immediately have to get into that severability issue. So, you can't really predict. It's like fortune telling. But I thought I can at least say that I'm very confident that we made the argument as forcefully as we possibly could. And I think the justices really got it. Was that your impression too, John?
I was very encouraged by the line of questioning from the justices. All of them, even maybe the one that was the one of the seven that was most skeptical, but all of them sort of presumed that at least part of this was unconstitutional. All of them seemed to agree as a baseline measure, as they should, that 208 can't exempt itself from the Constitution. So that's really good. When you got every justice agreeing with you that your argument that the law is unconstitutional is the correct one, that's a really, really nice place to be. And then the discussion just focused on, okay, well then, how are we going to proceed from here? Are we going to sever it? And on that question, I think there was a majority of skepticism that you could sever out the unconstitutional portion and let the other portion proceed. And what really struck me is when Justice Montgomery asked opposing counsel, he goes, hey, look, is it really reasonable to believe that voters would vote to enact a tax that couldn't be spent, particularly in this field where the voters arguably got involved in the education arena because they wanted to do something that the legislature wasn't doing. And then for the defense to rely on this argument that, well, even if you agree that this money, it can't exempt itself, the legislature can override it. Well, that doesn't make sense. I mean, voters never would have voted for a proposition, one, where the money couldn't be spent, a tax would be collected, but the money couldn't be spent. And the only thing that would save it is a legislative override. I think that that was a pretty weak argument. The other side did not have a strong answer for that. And I think that the court's skepticism about that was apparent. So
yeah, I thought so too. I thought that really came through. And in fact, if I remember correctly, Justice Montgomery basically asked that question twice in one way or another. And both times opposing counsel was really unable to provide a satisfactory answer. I mean, he was basically forced into the position of saying voters would have wanted to raise taxes, but not to spend the money. And that seems like so, let's be generous, so counterintuitive that I think a lot of people in the courtroom thought, that's not really the best possible argument. So that stood out to me also. This is just procedurally, it was kind of an unusual hearing in the way that it went, because, normally you have 20 minutes on each side. One side speaks, second side speaks, then the first side gets a short rebuttal. What happened today was that after our side went first and the other side was arguing, and the time was called, and Justice Montgomery still had questions, and he kept asking questions after that. And it showed his questions were pretty challenging to the other side. And then the attorney for the Department of Revenue was there, and was called up to answer questions, even though he had not been expected to speak. And that was pretty unusual. He only answered one or two questions, and then it went back to our side. That was a pretty unusual procedure. And I think it shows that the justices are very engaged on this. And I think they have some serious problems with the other side's position. Now, I say that, I always want to say, you can never tell from an oral argument how it's going to go. Sometimes justices will ask questions that sound like they're on the other side, as opposed to where they actually are, because they want to sound out the best possible arguments, and they want to cover all their bases, make sure they've thought of everything before they write an opinion. So sometimes they'll pretend to be on the other side than what they really are as a result. So you can never really tell what they're thinking. But I think that some of the questions that the other side was posed were very challenging, and obviously I disagree with them, so I'm somewhat biased. But I thought the answers were pretty weak on that side.
Yeah, I totally agree. And look, I want to make one other point that I don't want to be lost here. The proponents of this measure could have avoided all of this. When somebody runs a ballot initiative in Arizona, or when a group runs a ballot initiative, they can do it as a statute, or they can do it as a constitutional amendment. The difference being that you need more signatures to qualify for the ballot if you run it as a constitutional amendment than you do if you run it as a statute. Now, while the proponents, who, by the way, were in large part out-of-state moneyed interests, were drafting this proposal and getting it on the ballot, getting it qualified for the ballot, they went to Legislative Council, which is a nonpartisan body, and they said, hey, basically, is this thing constitutional? And Legislative Council told them exactly what the plaintiffs are contending in this case, that no, it's not. You can't statutorily exempt yourself from the Constitution. So they had an opportunity at that point to run it as a constitutional amendment, but they chose not to. And I think that's a real problem for them, frankly.
Yeah. Now we're going to see if there's any questions in a second. Remember that if you have any questions, press *9 on your phone in order to be added to the queue to ask questions. But like you said, John, the people, I think, were warned. And not only was it the Legislative Council, but, this case went up to the Supreme Court already once before the election, where there were questions about whether it was being handled properly going into the election, whether voters are being told the whole story. And if you read the opinion that the court issued, there's a footnote where they say, there's some, and they hint at it. They say, we will talk about the constitutionality of this whole thing later, is basically what they say. And so now here we are back in front of the Supreme Court.
Tim, before we open up questions, I know you covered part of this, where do things go from here? So as you mentioned, the court's going to issue a decision. Of course, the court always says it's going to do it in due course, meaning whenever the court would like to issue a decision. I thought it was really nice for our side. I thought it was really an important thing for our side to say, to ask the court, hey, give us your decision, give us your order before you give us a written opinion, in the hopes that the court will issue an expedited ruling one way or the other, so that there will be certainty on this issue. Dom Dre mentioned this is one of those rare occasions where every single branch of government, the legislative leaders who we represented, the governor who weighed in as an amicus, the state treasurer, they all asked the court, hey, give us a decision. We need clarity on this issue. Please do it as quickly as possible. So hopefully we'll get an order in relatively short order. Hopefully that would be a favorable order. And, you know, as you mentioned, it could resolve the entire thing one way or the other. If the court wants additional fact finding, or if it wasn't, you know, fully convinced on some of the legal issues, of course, it has the option to, you know, send it back down to the trial court for further development of the factual record, et cetera, et cetera. But I would expect if I was a betting man and I'm hopeful that there'll be a decision that issues in relatively short order, at least on these preliminary questions, and maybe it resolves all of it.
That's right. Now, remember, if you're listening in and you'd like to ask a question of us, just hit *9 in order to be added to the queue, and you can then ask a question of us regarding today's hearing in the Prop 208 case. You know, John, you mentioned the state treasurer and the governor filing briefs in this case. I think it's a good opportunity to mention that today's hearing our side was presented by Dominic Dre, who's the former Solicitor General of Arizona. Our clients are the Speaker of the House and the President of the Senate. Both houses have passed resolutions that endorse our proceeding with this case. The governor, as you said, filed a brief urging the Supreme Court to take and decide this question as quickly as possible. So did the treasurer. These are all points that Dominic got into in his argument. I think that shows how much credibility there really is behind this case. You know, a lot of the time when there's a constitutional challenge to, especially to a ballot initiative, frankly, but whenever there's a lawsuit that challenges the constitutionality of something like this, you know, it's hard sometimes for non-attorneys to assess how plausible the arguments that are being made, because, you know, sometimes you dress up an argument, it sounds more plausible than it really is. I think it's really an indication of how serious these constitutional flaws are with Prop 208, that basically the whole state government of Arizona has said, you know, this is a real problem for us. We don't know how to handle the fact that this thing comes in and imposes this massive tax, orders this kind of spending, it tries to exempt itself from the constitutional spending limits, ignores the rules for how you raise taxes. If this is allowed, what's going to happen next? I mean, if we're going to have ballot box budgeting into the indefinite future, what is that going to do to the economy of Arizona? I was born in California, so I know how bad things can be. I mean, let's just put it that way, right? In California, it has suffered from ballot box budgeting for generations now, where instead of the legislature following the balanced budget rule like it's supposed to, you have voters passing taxes followed by spending requirements, or spending requirements with no taxes, so the state's going into debt, all these complicated mandatory spending. So nobody can rationally plan how to do the budgeting for the state. We do not want to get into that kind of a mess here in Arizona. And by the way, this is a point worth mentioning, is that Arizona has a very unique portion in its constitution, very unique provision in the Constitution. No other state has this, that says voters can do by initiative what legislators can do in the House, in the state legislature, and anything legislators cannot do, voters cannot do. No other constitution has that. Now, everybody knows that that's basically the rule, but no other constitution has an explicit provision in its constitution that says that. And I think that's because Arizona has, you know, we have a proud tradition of the ballot initiative process in Arizona, but we also recognize its limitations and the importance of constitutional restraints, both on our elected representatives and on the voters when they pass ballot initiatives, in order to prevent, you know, the tyranny of the majority, as they call it, right? So, John, any final thoughts? I don't seem that we have any questions. Do we have any questions out there?
Just real briefly, I guess, if we're waiting for any more questions, then if we don't get any, why don't we go ahead and sign off? But, you know, I think, you know, Arizona, in my view, is better than California in virtually every conceivable way. One way, however, where our direct democracy provisions are somewhat in need of improvement is the Voter Protection Act, which says that if a measure passes as a simple statute, the legislature can't then go in and fix that anything that was passed by simple statute. So that includes even technical changes. So what that means is that there's really no whoopsie daisy for Arizona voters once they pass something by simple statute, if it turns out to be a really, really bad idea as a matter of policy, or if it just turns out that some piece of it isn't working because the legislature can't go in there and correct it. And anybody who's familiar with the legislative process knows that that process works out a lot of kinks ahead of time, and the legislature can always go back in and fix them down the road. All that stuff is out the window when we're talking about statutory direct democracy initiatives. So that's why we got to be real careful that these things are fully lawful, fully constitutional at the outset, and voters know what they're getting into. And this thing was not constitutional. Voters did not know what they were getting into with it. And, that's the whole reason we brought this case.
Ironically enough, actually, if you Proposition 208 actually violates the Voter Protection Act in one way. There's a portion in Prop 208 that says that the legislature is not allowed to repurpose the money that it raises under any circumstances. The Voter Protection Act actually gives the legislature that authority in certain rare circumstances, and it's not common, but the legislature is allowed to do that under some circumstances. So ironically enough, Prop 208, among its many other constitutional flaws, it also violates the Voter Protection Act. Now that issue is not in front of the Supreme Court today, but I just find it funny that there's so many different constitutional problems with Prop 208. Now I understand we have a question online. Let's hear what the question is. Caller, you'll have to unmute your line in order to ask your question.
Yeah, my question is, who's financing opposing counsel? Who are the main financiers?
I don't actually know the answer to that, John. Who do you know the identities of the backers of Prop 2? I mean, it's the supporters of 208, of course, are the people who are paying to defend it. But no, I don't think we do know that, do we?
So the Invest in Education campaign is the defendant that intervened to defend the legality of the lawsuit, even though the state was the only party that was named. So presumably the Invest in Ed campaign are the financial backers of the lawsuit. We know that for the initial proposition, much of the money came out of a organization in Oregon that put a lot of the initial money behind the original campaign.
And this goes to what you were saying about the Voter Protection Act in Arizona, that the reason why Arizona tends to attract out-of-state interests supporting, financing ballot initiatives is because of our Voter Protection Act, which is so stringent that if you're an out-of-state progressive and you want to remake the entire economy of the United States, what you want to do is you want to start out by getting something passed in Arizona as sort of a bellwether state, right? Or California is another one, but California is very expensive to pass ballot initiatives because the population is so large. Arizona is a little different than that. So Arizona tends to be a target state for out-of-state interests seeking to, pass their various soak the rich proposals or whatever it might be. Do you have any other questions out there? Well, John, I think that you and I are such persuasive lawyers that we just answered everybody's questions as it was,
Yeah, if only the judicial panels were this.
Well, people, thank you very much. Oh, do we have another question, Caroline? Looks like we might have another. No? Okay. Thank you, everybody, for joining us today and talking about today's hearing in the Prop 208 case. We could not do our work in defending the. We do have another question. Please go ahead.
Hello?
Yes, please. What's your question?
Yeah, I've got a question for you. The legislators can refer issues to the ballot, but they can't violate or backdoor the 2/3 requirement to raise taxes. So how could this initiative be constitutional? How could 208 be constitutional?
That's a great question, and that's one thing that we're going to be asking the courts to answer in the ideally we won't have to, but that is one of the questions that we will be asking the courts to answer in the coming weeks and months, because the 2/3 vote requirement for tax increases says, what it says in the Constitution is, any act that raises taxes has to obtain the votes of 2/3 of the members of the state House and the members of the state Senate. Obviously, a ballot initiative does not do that. So because it doesn't go through the legislature at all. And so one of the questions in this case, now this again was not something that the justices talked about in today's hearing, but one of the questions in this case is, given that that's the rule for, quote, any act that raises taxes, does that also mean that the initiative process can be used to raise taxes without amending the Constitution? Because that 2/3 requirement is a constitutional requirement. So you can't just, as you say, backdoor it, get around the constitutional limitation by passing it by a ballot initiative that is just an ordinary statute. That's a very serious problem. Well, John, again, thanks for joining me to talk with people about this. And again, a reminder that we can't do the work that we do in defending taxpayers, property owners, citizens of Arizona, and their constitutional rights under both the state and federal constitutions without support from people like you. You know, we are funded by people who agree with the work that we do and send us what they can afford to support our work in defending constitutional rights, not just in Arizona, but across the entire country. So we're very grateful for your support. And please keep an eye on our blog, In Defense of Liberty. That's all one word, indefenseofliberty.blog, to follow our day-to-day operations here at the Institute, not only with regard to taxes and legal and constitutional issues, but with regard to healthcare policy and all sorts of different education policy, all sorts of different things that we cover here at the Institute. Any last words, John?
No, thanks very much, Tim. Thanks to all the callers, and we will certainly keep you posted on any developments in this case.